Welcome to Talk Testimonies. We are diving deep into the arguments behind major Supreme Court cases, making them, well, easier to understand.
And today, we're tackling a really interesting one. Denard Stokling versus the United States.
Yeah, this one gets right into the weeds of federal sentencing law. The big question is whether a robbery conviction out of Florida counts as a violent felony under the Armed Career Criminal Act, or ACCA.
Exactly. And it all hinges on this idea of physical force. What level of force does Florida robbery require? And does that match up with what the Supreme Court means by violent force for ACCA purposes? It sounds simple, but it's really not.
Definitely not. So let's give the bottom line first. The arguments really went back and forth on whether Florida's definition, which interestingly can include just slight force overcoming slight resistance, actually meets that federal ACCA standard.
Right. Mr. Stokling's side argued, no, it absolutely doesn't. The government, on the other hand, said, yes, it does, and pointed to, the long history of how robbery has been understood in common law.
Okay, so let's unpack those arguments. Where should we start? Maybe with the petitioner, Mr. Stokling.
Sounds good. Brenda G. Brynn argued his case. Her central point was that, look, the Supreme Court invalidated a big part of ACCA, the residual clause, back in 2015.
Right, that clause was deemed too vague.
Exactly. So Brynn argued, now, for a state robbery conviction to count under ACCA, the crime itself has to have violent force as an element. It has to be baked into the definition of the crime.
Okay, so the argument follows. Florida's robbery law doesn't require that level of force. You said slight force can be enough.
That's what she contended, yeah. Slight force to overcome slight victim resistance. And because of that relatively low bar, if you apply the categorical approach.
Which means looking just at the law's minimum requirements, not the specific facts of Stokling's case.
Precisely. Then, under that approach, no Florida robbery conviction should automatically qualify as a violent felony under ACCA. It just doesn't meet the required threshold as written.
Wow. And she also mentioned something about armed robbery in Florida.
Yeah, that was interesting. She pointed out that even an armed robbery conviction doesn't necessarily mean the person, used or even brandished the weapon.
Seriously, just carrying it is enough.
Apparently so under Florida law. Just having it on you during the robbery can get you that charge.
Okay, and this gets even more specific when you look at jury instructions in actual cases, right? The dollar bill example.
Exactly, she brought that up. Florida case law apparently says that resistance can be as minimal as, the tightening of one's hand momentarily on a dollar bill before letting go.
And that can lead to a robbery conviction, not just theft.
That's what she argued qualifies as enough resistance, yes. And that conviction could then potentially lead to a 15-year mandatory minimum under ACCA. It really makes you question the scale.
Yeah, is that the kind of violent felony Congress was thinking about?
That's the core question. Brynn contrasted this with the Supreme Court's language in Curtis Johnson, another ACCA case. That case talked about substantial force, using words like, severe, extreme, furious, vehement, strong, and powerful.
Much stronger language than slight force.
Definitely. She argued that the typical Florida robbery, based on that minimal standard, just doesn't rise to that level of, truly violent force described in Johnson.
But didn't Johnson also mention force capable of causing physical pain or injury? The government picked up on that, right?
It did, yes. But Brynn's counter was that you have to read that phrase within the context of defining violent force. The emphasis, she argued, should be on the violent part, the substantial nature of the force, not just any theoretical possibility of minor pain.
So things like a minor shove or grabbing something, even pinching, those might be physical force, but maybe not violent force in the ACCA sense.
That was her point. It shouldn't automatically trigger these huge sentencing enhancements without considering the actual degree of force involved.
And applying the categorical approach means looking at the least culpable conduct the law covers.
Yes. You have to examine real Florida cases and see what's the minimum conduct that gets someone convicted of robbery. And she argued that in many of those cases, there's actually no evidence the victim felt any pain or suffered any injury.
Which highlights the potential disconnect.
Right. She even suggested Florida might be a bit of an outlier here, claiming maybe only 4 or fewer states have robbery laws that are this broad, covering any resistance and prosecuting for such minimal force.
So the defense is saying you can't just look at the words force and resistance on paper.
Exactly. You need, as she put it, a deep dive into state law to see how it actually works in practice. It's about the real-world application.
And her proposed standard for ACCA was?
Something like force that's substantial enough that you'd reasonably expect it to cause pain or injury in a typical scenario, not just in some freak outlier case. A higher bar.
Did she address the idea that Congress probably did intend for robbery to be covered by ACCA when they expanded it?
She did acknowledge that. But she pointed out that Congress initially set up two ways for crimes to qualify. That narrow elements clause we've been discussing focused on force.
And the much broader residual clause, the one that got struck down.
Right. And she made a subtle but important point about the 1986 amendment to ACCA.
What was that?
The word robbery was actually taken off the list of specifically named crimes that automatically qualified, while burglary stayed on.
Huh. So the argument is, Congress intended robbery to qualify only if it met the elements clause, specifically the force requirement.
That was her interpretation. It wasn't supposed to be automatic just because the crime was labeled robbery. The focus shifted to the element.
And she used a previous case, Duane Salvarez, to support looking at actual case applications.
Yes, arguing that's how you determine if a law truly covers nonviolent conduct in practice.
Bringing up that Michigan spitting case.
Right, as an example of how state courts define elements differently, and how federal courts have to respect those state interpretations, like Curtis Johnson established.
So she pushed back hard on the idea that Curtis Johnson only excluded something tiny, like a mere tap on the shoulder.
Very hard. She argued Johnson set a much higher standard, a substantial degree of force.
And her conclusion was that many Florida robbery cases just don't meet that standard.
Correct. She argued the conduct in several Florida examples simply does not amount to that level of substantial force. Often it's momentary, one-handed actions, no real harm done.
So don't focus on a hypothetical, typical victim. Focus on the force actually used by the defendant in real cases.
Precisely. And in Florida, that force is often minimal.
Okay, a very clear picture of the petitioner's stance. Let's switch gears. What was the government's argument presented by Frederick Liu?
The government leaned heavily on history and tradition. Their main thrust was that common law robbery going way back has always involved force sufficient to overcome the victim's resistance.
And they argued that standard is common.
It's very common. They said it's present in the basic robbery statutes of over 40 states, including Florida, and it was even part of ACCA's original 1984 definition. So this isn't some new or unusual standard.
And their take on the 1986 amendment was different.
Completely. They argued that when Congress amended ACCA, they took that core element force overcoming resistance and made it central to the new elements clause. It was a continuation, not a narrowing.
So if the court agreed with Stokling,
Then the government argued even classic common law robbery wouldn't qualify as an ACCA predicate. They claimed the petitioner couldn't find any state's basic robbery law that would meet their proposed stricter definition. It would effectively write robbery out of ACCA.
did the government use Florida case examples too?
They did. They pointed to Rigel, a case involving a bag snatching where there was a struggle, the strap broke, and the court called it robbery.
Showing that force overcoming resistance is the standard in Florida.
Exactly. But they also used the RP case, the camera grab, where there was no resistance, to show that without resistance, it's not robbery in Florida.
That distinction seems crucial for them.
It was. It highlighted that victim resistance and the force used to overcome it is the key differentiator between theft and robbery in Florida.
So their picture of Florida robbery is inherently a violent contest over property.
Yes, where the victim resists and the defendant uses force, even if it's just, quote, the slightest resistance and the slightest force used to overcome it, that still constitutes this violent contest in their view.
What about the putting in fear aspect of Florida's law?
They addressed that too. Liu argued that Florida courts consistently interpret putting in fear to mean fear of bodily injury, which directly satisfies ACCA's requirement for a threatened use of physical force.
And then they believed Congress understood all this common law context.
Absolutely. They argued Congress was fully aware of this long-standing definition of robbery when they passed and amended ACCA, and they viewed these takings against resistance as inherently violent.
So Congress intended to broaden ACCA's scope, and they thought robbery, as commonly understood, would fit the new elements clause.
That was the argument. No expectation that the definition needed to be drastically narrowed.
And how did they connect this back to Curtis Johnson and force capable of causing pain or injury?
They argued that the force involved in common law robbery overcoming resistance is inherently force capable of causing pain or injury. They saw it as directly aligning with the Johnson standard of substantial force.
So even minimal resistance met with force equals a physical struggle, which equals violence.
Yes, both in the ordinary English sense and under common law. It's the physical confrontation itself.
And they disagreed that Florida's an outlier.
Strongly disagreed. Said Florida's law tracks common law principles found in Blackstone and that over 40 states have similar basic robbery laws. Florida is typical, not unusual.
How did they handle Brynn's point about Johnson rejecting the mere touching standard from battery law?
They made a key distinction. They said Johnson rejected the misdemeanor battery definition of force, mere touching, but it did not reject the felony definition of force inherent in common law robbery, overcoming resistance. Two different levels of force for different crimes.
And they cited Florida case law, like Walker, to show Florida courts make that same distinction.
Correct. Showing that Florida law distinguishes between simple touching and the greater force needed for robbery.
So for the government, that phrase, capable of causing physical pain or injury, from Johnson, it's just a way to explain what violent means in ACCA.
Pretty much. It's a qualitative assessment. Is this the kind of force that can cause harm? Not necessarily a measure of how much force was used. It's a gloss on violent.
And force sufficient to overcome resistance is the practical way to measure that, to distinguish it from mere touching.
That's how they framed it. It quantifies the force needed beyond just incidental contact.
And a purse snatching where the victim holds on and resists.
That's a physical struggle over property, in their view, and squarely within ACCA.
They also use the Robinson case.
Yes, to show that Florida's Supreme Court clarified. Simple snatching without resistance is just theft. Resistance is the key. If it's present and overcome by force, it's robbery.
So ultimately, they argued violent should just mean violent in the everyday sense.
Essentially, yes, that a physical struggle to take property against someone's will fits the ordinary understanding of violence, and that's what Congress intended.
Okay, we've got both sides laid out. What about the rebuttal? What did Brynn come back with?
She went right back at that common law argument. She pointed out that historically, common law robbery didn't always require physical resistance.
Like the Blackstone example.
Exactly, the example of snapping a watch chain. No resistance overcome there, but still considered robbery.
So applying the government's logic would wrongly label even that as violent force.
That was her implication. She also argued Florida law has evolved beyond common law, potentially sweeping in things like resisting arrest after a shoplift.
And she hit hard on the mismatch between these slight force robberies and ACCA's purpose. Right.
Absolutely. That was a major theme. Treating these minimal force incidents as predicate felonies for 15 years to life sentences seems inconsistent with targeting the worst of the worst, the offenders most likely to use guns violently.
There's no predictive value, she argued.
Right. Using slight force in a theft doesn't really tell you if someone's likely to commit future gun violence.
And she put the ball back in Congress's court.
Pretty much said, if Congress disagrees with this interpretation and wants these minimal robberies to count, they need to rewrite the law explicitly. The court shouldn't stretch the current language.
She also touched on the old residual clause again.
Yeah, reminding the court that while it did sweep broadly, maybe even covering pickpocketing due to risk of confrontation, its vagueness is why it was struck down.
So don't compensate for losing that broad clause by overreading the elements clause.
Exactly. The elements clause requires violent force as an element, and the court shouldn't expand that just because the residual clause is gone. Stick to the categorical approach Congress chose, and if they don't like the results, they should amend ACCA.
Okay, that brings us to our 10th chair perspective. Time to step back and offer an additional view, considering everything we've heard.
All right, pulling up that 10th chair, this case really highlights a fundamental tension, doesn't it?
Definitely. Between Florida's very broad robbery definition and ACCA's focus on truly violent felonies.
You have the government emphasizing common law history, the idea of overcoming resistance, which has weight. But then you have the petitioner pointing to these actual Florida examples, the dollar bill, the minor grabs with slight resistance that just feel different.
They don't intuitively scream violent felony in the way ACCA seems intended.
Right. ACCA is about identifying and imposing much harsher sentences on individuals deemed particularly dangerous, often based on a history suggesting future violence, especially with firearms. Does a conviction based on overcoming the slight resistance of someone momentarily tightening their grip on a dollar bill really fit that profile?
It seems like a stretch.
And the categorical approach forces us to look at that least culpable conduct covered by the statute. We can't just focus on more serious robberies. We have to ask if the minimum conduct required for a Florida robbery conviction meets the ACCA standard of a violent felony.
And based on the arguments, that minimum seems quite low.
It does seem to fall short of the substantial degree of force that cases like Curtis Johnson and the overall purpose of ACCA seem to imply.
So the 10th chair perspective would lean which way?
Leaning towards a narrower interpretation here. While acknowledging the historical points, the specific context of ACCA and its focus on genuinely violent conduct suggests that a Florida robbery conviction predicated solely on slight force overcoming slight resistance probably shouldn't automatically qualify as a violent felony under the Elements Clause. The definition just seems too broad to fit ACCA's specific purpose without potentially sweeping in conduct that isn't indicative of the kind of dangerousness ACCA targets.
That's a really thoughtful perspective from our 10th chair. So that was our deep dive into Denard Stokling v. United States. We've really unpacked the arguments around violent force, state law definitions, and the complexities of the Armed Career Criminal Act.
Yeah, it truly shows how intricate statutory interpretation can be and how important that categorical approach is, for better or worse, in determining these kinds of sentencing outcomes.
So for everyone listening, what do you think? Does Florida's definition of robbery, potentially capturing such minimal force, really align with what Congress intended when it created ACCA to target career criminals with violent histories?
It's a critical question with real-world consequences for potentially long prison sentences. Thinking through these nuances is vital for understanding our justice system.
We encourage you to explore it further. Understanding these legal debates helps us all stay informed.
Absolutely. Join us next time for another in-depth exploration.